Yes, in that sack. But let me make another one because I know you need one. I totally slipped my mind. That happened. Sorry about that.
That won't happen here because he was paying attention.
All right, let's roll.
Good luck, okay?
You're welcome to take a seat. That's what I have to for and I am spinning it up. jail staff, excuse me, I cannot talk today. Jail staff said there is a holdup, so they will be just a couple more minutes.
Okay, thank you.
Mhm. All rise. Court is now back in session.
Can I have a seat? I understand you're Mr. Ramos Valdez, is that right?
Yeah.
It's nice to meet you. This is State of Washington versus Ramos Valdez, case number 23-1-076041, Kent designation. If you all can tell me your names, starting with counsel for the state.
Luke Parker for the state, also present as victim advocate Kimberly Luna.
All right, defense.
Good afternoon, Your Honor. Deborah Wilson. I'm standing in for the attorney of record, Susan Sobel, who is currently on leave. Our client is present to my left and has the assistance of a Spanish-speaking interpreter today.
The interpreter, please state your name and her credentials.
Thank you. Christina Woltz, Washington State Court Certified Spanish Interpreter. I'm permanently sworn. My oath is on file at the AOC, and we're having a little audio difficulty right now. Would you please give us just
Sure.
a second? Sorry, Your Honor.
No worries.
Yeah. Yeah.
Hi.
Thank you to the interpreter for your assistance again. It's nice to see you. There is media in the courtroom. Does anybody wish to be heard, or should we just proceed? Mr. Parker?
State does not wish to be heard.
Ms. Wilson?
Neither does.
All right. We are here for sentencing. I did receive the reports from both parties prior to sentencing today. Is there anything preliminarily before I hear your recommendations? Anything preliminarily from the state?
At the time of the plea, Your Honor, the state elected to file a non-felony plea agreement. We did file the felony plea agreement in the state's recommendation form. The non-felony plea agreement doesn't say much, but just to complete the record, we've printed out a copy, provided that to defense, and we anticipate on filing that.
And do you, so not the statement of defendant on plea of guilty, just the plea agreement itself, is that correct?
And only with respect to count 2.
Sure. All right. Ms. Wilson, anything that you need from me as to that issue?
No, Your Honor. I'll just need to review that with my client at the end of the hearing. I did warn him that this would be happening today.
Okay. Anything else preliminarily, or do you want to do that now, or anything else preliminarily before I hear the recommendations for sentencing?
We can do it at the end when we review the rest of the paperwork if
All
that
right.
works for the court.
Mr. Parker, what did you want me to know?
Your Honor, Mr. Ramos Valdez pled guilty to 2 charges, assault in the first degree and reckless endangerment, and the parties are before the court with an agreed sentence recommendation. Assault in the first degree is a serious violent Class A felony. The maximum possible penalty is up to life in prison and a $50,000 fine. Mr. Ramos Valdez has no prior criminal history. His offender score is 0 on that charge, which means his standard sentencing range is 93 to 123 months. The state's asking this court to impose 93 months and to impose 36 months of mandatory community custody following his release from prison. The state's asking this court to order no contact for life with Jorge Moreno Rios and Tiana Gomez Hernandez. Separate and apart from that condition of sentence, parties have agreed to a no contact order, which we will be handing forward at the conclusion of this hearing. Felony firearm registration is mandatory on a serious violent offense where a firearm is used. So we would ask the court to impose that accordingly. The state's asking this court to order restitution in an amount to be determined at a later date, and takes no position on other fines and fees. The state's asking that this sentence run concurrent to count 2. Count 2 is a gross misdemeanor charge of reckless endangerment. the maximum possible penalty is up to 364 days in jail and up to a $5,000 fine, and there is no standard sentencing range. Mr. Ramos Valdez has already served the maximum on count 2, and we would just ask that the court impose and close on count 2, concurrent to count 1, with no further conditions on count 2. There were 3 victims in this case, Your Honor. Jorge Moreno Rios was shot in the neck. His girlfriend, Tiana Gomez Hernandez, wasn't shot, but she was sitting right next to him, and she was certainly shot at, and she was pregnant at the time. And then close in time on the same roadway, different milepost, Manuel Martinez was shot at and his car was hit. Mr. Martinez has no input for today's hearing. He did not wish to be involved in the process from the start, and he did not wish to be contacted further by the prosecutor's office. Mr. Moreno Rios and Ms. Gomez Hernandez have spoken extensively with Ms. Luna, who, after the state's presentation, will offer a statement, Your Honor. The state would like the court to know that this plea agreement took into consideration the evidence in this case, which the state felt was strong evidence, the mitigation that was provided by defense, which didn't specifically endorse a mental defense if it went to trial, but certainly led the state to believe that if this had proceeded to trial, it would have been under a mental defense. As the state would also wish the court to consider the fact that one of the victims did not wish to participate, while 2 of them were very much participating and have their own feelings about what an appropriate sentence in this case would be. If the court has any questions, I'm happy to address them, but I would just ask the court to hear from Ms. Luna with respect to the wishes of Ms. Gomez Hernandez and Mr. Moreno Rios.
I don't have any questions, and yes.
Good afternoon, Your Honor. Victim Advocate Kimberly Luna on behalf of the named victims. I've been working with Mr. Moreno Rios and Ms. Gomez Hernandez for the last 16 months. Though they were unable to appear today, both Mr. Moreno Rios and Ms. Gomez Hernandez have asked that I share input to the court on their behalf. Mr. Moreno Rios and Ms. Gomez Hernandez do not support the plea agreement. Mr. Moreno Rios was driving on the freeway when he was shot and struck in the neck, just a couple millimeters from his carotid artery. In his vehicle was Ms. Gomez Hernandez, who was 6 months pregnant at the time. By the grace of God, they were able to manage pulling his vehicle over as the bullet remained lodged in his neck. Mr. Moreno Rios was not the only one shot at. He just happened to be the only one who was hit. This incident could have ended very differently. Many people could have been injured or died that night. And for the rest of their life, Mr. Moreno Rios and Ms. Gomez Hernandez will have to live with the trauma brought on from Mr. Ramos Valdez's disregard for human life. For this reason, they request that the court impose the maximum amount of time. Thank you.
Thank you. Anything further from the state?
No, Your Honor.
Ms. Wilson, what would you like me to know?
Good afternoon, Your Honor. As I mentioned, I am covering for Susan Sobel. I met Mr. Ramos Valdez at his plea, so I've known him just a couple of weeks now, and I had the opportunity to review some of the materials from Ms. Sobel that led to the resolution of this case. As the court is aware, he has no criminal history. 93 months is an incredibly long time. I think we're all very grateful that this didn't end any worse than it did. It's obviously a frightening incident that could have gone much worse, and I think we're all feeling very lucky that it didn't. Our client was very unwell at the time of this incident. He was evaluated by Dr. Patterson, who wrote a report with his findings, and that was shared with the state. It seems as though he had been experiencing psychosis for about the 5 months leading up to this, including on the day of the incident. Fortunately, that seems to be a transient condition with abstinence and medication. He is no longer experiencing symptoms and is in remission, and hopefully that will just continue from this point forward, and he will never be in this courtroom or any other again for any sort of criminal matter. He did accept responsibility for this. He, again, is pleading to an assault 1, which is, a very serious crime, and following many years in prison, he will have at least 3 years of supervision by the Department of Corrections, which is mandatory, and they have lots of conditions and rules that they will place on him as well. I did want the court to know that he has continued family support. His sister, Jahida, is in the courtroom, along with one of his brothers, whose name I didn't get, but Jose. He has had family support. He's very grateful for that, and I think eventually when he is released from prison, whenever that is, and is transitioning back into the community, that will play a large piece in his continued wellness and success going forward. This is an agreed recommendation. We would ask that you follow that.
No.
It doesn't seem as though he wants to address the court at this time.
Mr. Ramos Valdez,
Hola.
your lawyer's already answered the question, but I also just need to give you the opportunity to talk to me. You don't have to. There's lots of reasons people don't want to talk to judges at sentencing, and I get them all. People are nervous, they're afraid they're not going to say the right thing, and they feel like their attorney has already said everything that needs to be said. That being said, I do make better decisions when I hear right from the people impacted, and if there is anything you wanted to tell me, I'd be glad to hear it, but of course I'll it will be just fine if you don't want to say anything. Is there anything you wanted to tell me?
Pues yo pienso que soy buena persona,
I think I'm a good person.
ya que lo que hice lo hice por las drogas.
What I did because of the drugs.
Ya, yo no pienso drogarme nunca más.
I never intend to use drugs again.
Thank you.
Es todo.
That's all.
Thank you for talking to me. I will make better decisions having heard from you and also having heard from the victims of your crimes. I will follow the agreed recommendation. You are not the worst thing that you've ever done. This is clearly the worst thing you've ever done. It is, you have a completely clean criminal history. We haven't seen you before, and of course, everyone in this courtroom hopes we won't see you again in this context anyway. Maybe for happy things like marriages and adoptions, but not for something like this. I will issue the no contact order. You may find when you're in prison that you want to contact the victims, that you want to do right by them, that you want to tell them you're sorry. You may not do so. You can't contact them even through a third person. Sometimes victims change their minds, and if they decide that it would be worth it to them healing-wise to have contact with you, they'll reach out to the victim advocate and ask that the no contact order be modified to allow them to contact you and you to respond. But even if they contact you, do not write back, because this no contact order is only a one-way street. It only prohibits you from having contact with them, not from them, for instance, writing a letter. And those things happen, so do not write back to them as long as this remains in place, which is life until I lift it, or somebody's sitting in this chair. So I will impose the 93 months, followed by 36 months of community custody. I know it's a long way out, but you have to immediately get in contact with your community custody or corrections officer upon release. I think it's 48 hours or something like that, and they're very strict about that. So make sure when it comes to the day of your release that you get into immediate contact with the person who's been assigned to your case. I am issuing that no contact order for life. I am issuing the firearm registration. That requires for 4 years after you're released from custody that you register with the sheriff wherever you're living. And it's an ongoing obligation that you have to register, and it's a gross misdemeanor if you do not. I do find that you're indigent, and I won't impose any fines or penalties other than potentially restitution. If the victims do request a restitution, we'll set a hearing. Does he waive his presence at that hearing?
He does, Your Honor.
Well, that will be noted. Mr. Parker, is there anything else you need from me in terms of filling out the judgment and sentence?
I don't believe so, Your Honor.
Ms. Wilson, anything else you need from me orally?
No, Your Honor.
Okay.
Thank you. Okay, so this is the misdemeanor. Yeah. Your Honor, may I start handing documents forward as I finish reviewing them? Okay.
Mr. Parker, do you know who took the plea?
For the state, Your Honor?
Do you know, sorry, what
Which
judge took the plea?
Judge Wiggs, Your Honor.
I should have noted, I'm also following the recommendation to impose and close on a misdemeanor.
Thank you.
Mr. Parker, did you not want me to check either box for the firearm restoration notification from prosecutor and then no contact, or did you just not have enough information from the victims about that? Let me take a look.
Yes, Your Honor. Your Honor, if there is a petition for restoration of firearm rights, my office will notify them, and I have checked that box and spoken to defense about it.